Welcome, everybody. Thank you so much for joining us, both in person and virtually. We are thrilled to have you here for today's Year in Review panel on democracy litigation in the U.S. Supreme Court and state Supreme Courts. I know there are still some people filing in. That's fine. I'm Miriam Seifter. I am a law professor. Oh, okay. I'm a law professor at the University of Wisconsin Law School and faculty co-director of the State Democracy Research Initiative here. I'm happy to be your moderator today, and I will speak loudly. This event is part of a series called Election Matters that is ongoing this year. It's hosted by the State Democracy Research Initiative, the University of Wisconsin's Elections Research Center, and we are grateful for generous sponsorship from the Wisconsin law firm Stafford Rosenbaum. To introduce our panelists today, I'm going to turn the floor over to Erin Deely, a partner at Stafford Rosenbaum.
Good afternoon, everyone. My name is Erin Deely. Thank you so much for having me. Stafford Rosenbaum is a full-service firm, but for many of us who work there, our election and political law work is the heart and soul of the work we do. That's why it's such a privilege for me to be able to introduce this incredible panelist of election experts. I could spend all day introducing these people, but it will be brief so we can get started on the important conversation ahead. Pamela Karlan is a professor at Stanford Law School, where she is also the co-director of the Supreme Court Litigation Clinic. She was the principal deputy assistant attorney general in the Civil Rights Division of the U.S. Department of Justice and former clerk for Justice Blackmun. Derek Muller is a professor at Notre Dame Law School, where he teaches election law, among other subjects. He is the co-reporter on a new restatement of law, election litigation, led by the American Law Institute. His writings have appeared in the New York Times, LA Times, and Wall Street Journal. Gauri Ramachandran, she is Deputy Director of the Brennan Center's Elections and Government Program, where she focuses on election security, election administration, and combating election disinformation. Before joining the Brennan Center, she was professor at Southwestern Law School in Los Angeles, where she taught a variety of courses, including constitutional law and courses in employment discrimination. She is a former clerk for Sidney Thomas of the Ninth Circuit. And then Riley Summers Flanagan. She is the founder and executive director of Upper Seven Law, a Montana-based nonprofit law firm whose core mission is to hold the powerful accountable. Before founding Upper Seven, she served as the deputy chief legal counsel for Montana Governor Steve Bullock, and she also clerked for Judge Thomas of the Ninth Circuit. Thank you all for being here today, and let's get started.
All right, thank you again. Let's give them a round of applause. Thank you so much again. It's really a thrill to be here with this group. If you will bear with me, I have to do two more obligatory things before we begin. One is a little bit of housekeeping. So for those of you in the room, please be aware that this panel is being live streamed to our amazing virtual audience. Thank you, virtual audience. This event has been approved for 1.5 Wisconsin CLE credits by the Board of Bar Examiners. Will conclude at 4:15 p.m. If you're here in person, there are CLE sign-in sheets that you walked by when you came in. Please be sure to sign those before leaving. And for those of you attending virtually, please listen for the passcode that I intend to remember to give around 4:05 p.m. At the conclusion of the panel, you'll watch for a Google form in the chat box, and you can complete that form with the passcode by 8 p.m. Central Time today. In addition, we're going to save time at the end of this panel for Q&A. So if you are here in the room, there are index cards available. You can write your question on a card, and folks will be coming around to bring those up to me. If you are on Zoom, please use the Q&A function in Zoom, not the chat, but the Q&A function to ask your questions, and we will get to as many as we can. Second, I want to offer some very brief remarks on why we're here and why we've chosen to dedicate an Election Matters panel to this topic of a Supreme Court and state Supreme Court year in review. Courts, of course, play a significant role today in shaping the future of democracy on issues from redistricting to voting rights to the administration of elections to whether and how people can hold officials accountable. So we wanted an Election Matters event to talk about and analyze what courts have been deciding in the year that has been. But the conventional end of term event thinks only about the US Supreme Court, and that strikes us as incomplete. State courts, as many of you well know, decide the vast majority of cases in the United States, and state Supreme Courts have issued very important decisions affecting elections and democracy. So we wanted to talk about state high courts too, as well as the interaction between the state and federal systems. And so we are thrilled to be here with this amazing panel. I'm going to start by asking each panelist to kick us off by highlighting a significant case or cases from the past year. And then after that, I'll pose a question while I gather yours, and we'll do audience Q&A. I also want to mention that there will be refreshments for those of you virtually, I'm sorry, but for those of you here in person, there will be refreshments outside this room when the event concludes, and we hope you'll stick around for that. Okay, so for opening remarks, we are going to start with Pam Carlin and then go down the row from there. So Pam, I turn it to you.
Great. So first of all, thanks so much for having me. And it's a real pleasure to be back in Wisconsin, see former students, former co-counsel, former co-authors here. John Hart Ely's Democracy and Distrust was one of the greatest works of 20th century constitutional theory. Ely developed what he called a participation-oriented, representation-reinforcing approach to judicial review, one designed to enhance rather than to supplant democratic decision-making. One of the central functions courts play in that theory is to intervene when, in John Ely's words, the ins are choking off the channels of political change to ensure they will stay in and the outs will stay out. A key theme of this term at the Supreme Court when it comes to democracy is the court's utter abdication of that responsibility. In my remarks today, I'm going to illustrate this by talking about two cases, Trump against the United States and Alexander against South Carolina State Conference of NAACP. But the theme runs across a much broader swath of the court's docket than that, as the court, for example, has kneecapped administrative agencies that are part of the democratic political process in favor of arrogating to itself ever more power in the service of a deregulatory agenda that allows the powerful to keep their power, the ins to stay in. The starting point for Trump against the United States is to recognize what Donald Trump was trying to achieve. He sought to remain in office despite the fact that a majority of voters and a majority of the electors in the Electoral College preferred a different candidate. First, he and his co-conspirators used knowingly false claims of election fraud to try and persuade states to change their electors. Second, they organized fraudulent slates of electors in several states. Third, they tried to use the Department of Justice to go after people claiming election fraud and to make false claims about the elections. Fourth, on January 6th, he and his co-conspirators told a gathering of his supporters that the vice president had the power to change the election outcome and then urged people to go to the Capitol to obstruct the certification proceedings. And finally, when that happened and there was an actual invasion of the Capitol, Trump and his co-conspirators exploited the disruption by redoubling their efforts to get members of Congress not to certify the election. The Supreme Court held, in the face of this frontal assault on democracy, that the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions within what they called his conclusive and preclusive constitutional authority. So the court held straight out that Trump's attempts to use the Justice Department to conduct sham investigations of the election, and indeed, there was more than just sham investigations going on there. There were questions about using the FBI to go into polling places and the like, but that these things not only cannot form the basis for a criminal prosecution, but they can't even be used as evidence in a prosecution going forward of what the president was trying to achieve. And this is terrifying when it comes to the integrity of US elections when faced with an incumbent who has no integrity. Second, the court held that a former president is entitled to at least presumptive immunity from all criminal prosecution for all of his official acts. And then they gave an extraordinarily broad definition of what counts as the official acts of a president. So, for example, the Chief Justice declared that a long recognized aspect of presidential power is using the office's bully pulpit to persuade Americans, including by speaking forcefully or critically in ways the president believes would advance the public interest. Now, how you're supposed to separate that out from his private interest in continuing to be president, which is not an official action, is something that the court gives us no real guidance on. They've kicked all of this back down to the district court, and it's going to go back up to the Supreme Court at least one more time before there can be any trial. The court ended its opinion by insisting that it could not, in its words, afford to fixate exclusively or even primarily on present exigencies. Our perspective must be more farsighted. But I think the court erred grievously in not looking at the present exigency. For the first time in American history, a president sought to prevent the peaceful transfer of power in response to the people's votes, the sine qua non of democracy. The court failed utterly in its role. Now, that was the last case the court heard argument in. And now I want to turn to one of the first cases of this term that the court heard argument in, because the court's indifference to the attempt of the ins to ensure that they will stay in and the outs will stay out was also on full display there in Alexander against South Carolina State Conference of the NAACP. Alexander was a variety of what is called a Shaw challenge. This is a challenge in which people challenge a redistricting plan on the grounds that race played too great a role in how the districts were drawn. And this has been a well-recognized claim at the Supreme Court since the 1990s. So what did the South Carolina legislature wanted to do? Well, they wanted to make Congressional District 1 a safe Republican seat. And it was a seat that was teetering on the edge of being a toss-up district. After the 2020 census, the existing District 1 was overpopulated by about 88,000 people, and the district right next to it, District 6, was underpopulated by about 85,000 people. So you can see what it's easy to do. Just move the people into another district, but that's not what the South Carolina legislature did. Instead, it moved 194,000 people around. And the people it moved around were predominantly Black. And they managed to keep the Black percentage of Congressional District 1 low enough that it would be a safe Republican seat going forward. Now, a three-judge district court familiar with South Carolina politics found a Shaw violation and said the predominant explanation for what was going on was race. And it also held that the legislature not only had a Shaw violation, but had deliberately attempted to dilute, to minimize the voting strength of Black South Carolinians. So what did the Supreme Court do here? Well, by a 6-3 vote in a decision written by Justice Alito, they reversed that decision. And what's particularly striking about Justice Alito's opinion is the way it treats a partisan desire to disadvantage a group of minority voters. So let me give you a kind of sense of how the court has moved over the last 3 or 4 decades. What the court has done is to move from Davis against Bandemer in 1986, where the court said, political gerrymandering, excessive political gerrymandering is unconstitutional and federal courts can do something about it, although they came up with a very strange test for what counted, to Veith against Jubileer in 2003, where all 9 justices agreed that excessive political gerrymandering is anti-democratic and constitutionally troublesome, but they split 4-1-4 on whether federal courts could do anything about it. To Rucho against Common Cause, where the court recognized that there was something wrong with excessive political gerrymandering, but held that there was no manageable standard by which courts could do anything about it. To Alexander, where Justice Alito's opinion suggests that naked partisanship is consistent with a presumption of legislative good faith. That is, it's legitimate. It's not that we can't do anything about it. It's that there's no problem here at all. And in parts of the country where race and politics are intertwined, what this means is that the Constitution has nothing to say. And I'm waiting now for the other shoe to drop on this, which is that the court is going to hold that partisanship is a defense not only to a Shaw claim of excessive race consciousness, but is going to be a defense to a claim of racial vote dilution in the first place, that the balancing of the equities allows a state to decide that it wants, for political reasons, to disadvantage minority voters. Now, what accounts for the counter-majoritarian turn at the court? A number of scholars have offered explanations of this. Nick Stephanopoulos gives a legal realist account in which he says that the court's decisions are empirically benefiting the Republican Party, whose presidents appointed a majority of the sitting justices. Let me just give you a date now, May 1969. Think about what is that? Why am I telling you about May 1969? Because that's the last time the Supreme Court of the United States has had a majority of members nominated by a Democratic president. Since then, the Supreme Court has been a majority Republican court. Mike Klarman says, look, it might not be consciously partisan, but the parties have deep ideological polarization and they disagree about values and they probably disagree about facts. And regardless of why the Supreme Court has abandoned majoritarian representation reinforcing judicial review, the current court and its democracy depleting decisions are a symptom as much as a cause of our present condition. At some point, I think the American people are going to have to confront that fact, and they're going to have to develop a political and constitutional response to the anti-democratic nature of our current court. As the great African-American writer James Baldwin long ago told us, not everything that is faced can be changed, but nothing can be changed until it is faced. We need to face the fact that the Supreme Court that was once a protector of democracy is now its antagonist. Thank you so much.
Our next panelist is Derek Muller.
Great. Well, thank you. Thank you so much for having me. It's a privilege to be here. Great to be back in Madison. I'll offer one or two brief thoughts on Trump versus United States, and then I'll talk about a few other cases. On Trump versus United States, it is interesting to me that the court sort of picks out, as Pam said, these conversations with the Attorney General, the FBI, as something sort of as core functions of the executive, but it kind of goes out of its way in the rest of the opinion to suggest there's at least some ambivalence in almost everything else that Jack Smith brought in the indictment. And so it doesn't seem like there are 5 votes on the Supreme Court right now to say that all of those things are protected. If I had to guess, when this case goes back to the district court, which found there was no immunity, is going to look at things like the conversations with Mike Pence in his role as president of the Senate, presiding over the counting of electoral votes, in some of the pressure to create alternative slates of electors in the states and purport to be the true ones and sending that paperwork along and so on. I think there's going to be a strong likelihood that the district court is going to find those things are all unofficial acts. But I think Pam is right, probably coming back to the Supreme Court in the event that the prosecution continues into January. So we'll see about that. But I think it's interesting that there's at least some doors left open at the end of this case. The Supreme Court did have several other cases relating to some speech-related issues, and speech-related issues, particularly, for public officials or things coming out of the 2020 election. So I want to highlight 3 of those cases, and some of them are a little bit more procedural. Try to think about what the takeaway is on each of these cases. So one is a case called Linkey versus Freed. James Freed was a private citizen who launched a Facebook page, as many of us have, for many years ago, posted information. He was then elected the city manager of Port Huron, Michigan. And then as the city manager, he would occasionally post things on his personal Facebook page about life and things that are happening both personally and relating to his professional responsibilities. Then COVID happened, and Kevin Linkey was not happy with the city's response to COVID and began to post a series of things on his Facebook page responding to the city manager. The city manager eventually began to delete some of them and then blocked him. He sued, alleging that this is a government actor abridging his First Amendment rights, bringing this challenge to say, you can't just censor my speech. The Supreme Court has punted on a couple of these cases, including a previous Trump case several years ago. But there was a unanimous decision from the court and Justice Barrett to say, essentially, we have to be a little bit careful when we're thinking about how we distinguish public and private acts for these government officials. Because if it's a public act, if it's state action, it can be covered by the First Amendment. There's protection. If it's just a private individual, we don't say that there's any First Amendment protection whatsoever in terms of your ability to communicate with that person. So the court looked and said, we're looking at 2 things. We want to know whether you've possessed the authority to speak on behalf of the state and whether or not you've exercised that authority on social media. And the court walks through a series of factors to think about. And I think the key takeaway from this is how messy and fact-specific it is. It's going to be very hard, I think, for plaintiffs to run into court and sue and say that they're entitled to be able to speak to their officials to the extent that they're not able to point to official government policy saying this is how you communicate to the public. If it looks like it's a private Facebook page, then it's probably going to be treated like a private Facebook page. Additionally, the court says we have to be very specific about the kinds of retaliation that are happening here. We are deleting a comment on one post. If you're posting about your kid's soccer game and then somebody is posting about your COVID response and you delete that, that seems like private conduct. But if you are blocking the user, you're preventing them from looking at anything on your page whatsoever and preventing them from interacting with you on a broad basis. So maybe that would be a step too far. So the court points out that when it comes to these elected officials, we don't have really easy answers as we think about how social media interacts with our ability to petition or speak with our representatives. That's going to be a deeply context-specific inquiry. Second was a case called Net Choice. It came up to the Supreme Court. This involves some statutes passed in Florida and Texas. They were trying to regulate social media platforms based on having millions of users, millions of revenue, whatever it might be. And the goal in these states, in Florida and Texas, was to regulate the content moderation policies, particularly of sites like Facebook and Twitter. The notion from Florida is that if you are going to moderate content on a page, you have to have consistency in how you moderate. You have to have an explanation to your users about why you remove information. Texas required that you would have viewpoint neutrality in how you are removing information. Again, the gist of this in Florida and Texas was the sense that Facebook and Twitter were censoring conservative viewpoints at the expense of liberal viewpoints, or censoring conservative viewpoints and enhancing liberal viewpoints. And the notion was that there are certain things that Florida and Texas wanted to protect in these cases. So Net Choice, a trade association that represents these social media platforms, brought a lawsuit. And the outcome was actually unanimous, although not quite on the reasoning. Unanimous decision to say that the lower courts should reconsider this case and send it back. Justice Kagan, writing for 6 justices, said, look, the problem here is that Net Choice is stepping in and saying there should be a facial challenge to the statute. That is, the statute is unconstitutional in essentially all of its forms and application. And the court says that's a heavy burden, and you shouldn't just lightly strike down statutes as facially unconstitutional, because Florida and Texas could very well say, we care about viewpoint neutrality. This is part of our police power as the state. This is something that we can exercise. But when it comes to First Amendment issues and the ability of platforms to be able to speak freely, or to say that the state is restricting their speech or their ability to speak, we have to be a little bit more sensitive. So we ask ourselves, the proper inquiry is, does this statute substantially apply in circumstances where it lacks a plainly legitimate sweep? So when we're looking at the problems that you think you have with this, with Florida's law or Texas's law, do we think that there's a lot of places where it's problematic, or only a handful? If it's only a handful, we can maybe have an as-applied targeted challenge. If it's a lot of places, you have to make that showing below. So that was what the majority said. Justice Alito, concurring in the judgment, agreed with that. 9 justices all agreed. So we're going to see another day this case, but then they sharply divided because there was a series of what Justice Alito called dicta about what Justice Kagan had to say about the rest of the opinion, to say that there was a fight between them, and this is where the fight is going to lead, I think, in the years to come. On the one hand, the majority, I think, believes, or at least characterizes, that these social media platforms are more like a newspaper. And we've had precedents from the Supreme Court saying we can't force newspapers to carry content. And if that's the case, right, they have this message they're trying to convey to people with their feeds, with how they communicate via an algorithm. And if that's the case, then we can't step in and force these content providers to do certain things, to present information in a certain way. For Justice Alito and the justices who were concurring in the judgment, they said this feels more like a shopping mall, another analogy used by the Supreme Court in a different case. It doesn't have a message to go to a shopping mall. It doesn't have a message to go to Facebook or Twitter. It just means that you are there, and there are people who are going to present information to you, and you should be forced to perhaps carry views that you disagree with. So that, I think, will be the dispute that we see going forward. And then finally, one more case called Murphy versus Missouri. This was a case sometimes called the jawboning case, where after COVID and the 2020 election, government officials from the CDC and elsewhere had been in contact with social media platforms like Facebook and Twitter to say that false claims about the 2020 election, or false claims about vaccines, or about the COVID pandemic, that there should be some content moderation about this. Twitter and Facebook were already doing their own things and moderating the content, but then a handful of people whose posts were taken down sued, and they sued the federal government. And that's because, again, we're dealing with the state action. That's the federal government is the actor here. And their argument was that the federal government was essentially pressuring these social media platforms to censor their speech in a particular way. And that was a First Amendment violation. And the court, a majority of the court, in opinion by Justice Barrett, punted on this substantive issue and said, you don't have standing to challenge this because a lot of you can't really point to any government speech. A lot of these posts were being censored in 2020 before you have any allegations that the government was talking to Twitter or Facebook. By 2021, it's very attenuated whether the government, a CDC official talking to the government in 2021 led to your Facebook post in 2023 getting taken down. You were asking for an injunction today. It's 2024. Also in the summer of 2022, when you filed this, the government had stopped communicating with these platforms about limiting information, about restricting information. So we're not even going to have to get into the issues about whether or not the government had a good reason of communicating true information about vaccines and about the 2020 election, or a bad reason. We don't have to get into that. And 3 justices dissented saying, oh, I think we should get into that. And I think we think that's very wrong on this front. But the takeaway from this, I think, especially if we're dealing with government pressure on private entities or government conversations with private entities that regulate speech, you're dealing with a sort of third party, right? You're dealing with this intermediary that steps in. I think it's gonna be a challenge for plaintiffs in the future without very specific instances they're able to point to of censorship or restriction of speech or whatever it might be to succeed going forward after this case. So those are the 3 sort of speech cases that have come out of that term.
Thank you so much, Derek. Your next panelist is Gowrie.
Thank you. Thank you all for having me. I really is flattering to be on this panel with all of these amazing panelists. So I'm going to talk today a little bit about the Murthy case that Derek was just talking about, and sort of use that as a segue into, I think, what I predict we're kind of going to see in terms of democracy-related litigation in both the state and federal courts during this election cycle and probably beyond. So Derek kind of explained, what the argument was that the plaintiffs were making in the Murthy case and how they sort of lost on these standing grounds. I thought I would tell you guys why we at the Brennan Center filed an amicus brief in this case. Most of the sort of evidence in the case and discussion in the case was really about COVID disinformation and vaccine hesitancy information online. So you might think the Brennan Center really doesn't have any expertise in public health. We don't. But we chose to file an amicus brief in this case on behalf of a bipartisan group of current and former state and local election administrators. And the reason we did that is that the theory of this case and the orders that the trial court in this case and the Fifth Circuit affirmed before it got to the Supreme Court, they were incredibly dangerous for just the notion of like truth and democracy and voters being able to like know where to go to vote, to like just to get like basic truthful information about elections. And that is because the plaintiffs in this case had named as some of the defendants the State Department, the FBI, and CISA, which is the Cybersecurity and Infrastructure Security Agency, which is a sub-agency within Department of Homeland Security. And one of CISA's functions is to support both private sector and public sector folks in state, local, and tribal governments who are doing things that protect critical infrastructure. So like the power grid, stuff like that, and elections are critical infrastructure according to an executive order. Part of CISA's mandate is to help share truthful information with the public, to warn the public about attempts to confuse them about elections. That is also part of the FBI's mandate, to warn the public about confusing information about elections. And CISA also sort of help support local election officials. And what they did during the 2020 election that became part of the sort of allegations in this case is they facilitated government officials, so like, local clerks, election clerks, things like that, and disinformation researchers, so people at universities that had student interns and people like that, going online and looking for false information about elections and trying to identify it. They facilitated communications between all of those people and the social media platforms. And if
We've had a request for you to move your mic slightly closer to.
I'll also talk louder.
There
Is
you
this
go.
better? Okay. So they did this, and part of the allegations in this case were that essentially this was a conspiracy between all these private sector folks at universities, these public sector folks and CISA. This was a conspiracy to censor speech on some sort of partisan basis. The people who were part of this sort of informal collaboration to like let social media companies know about things like incorrect information about where to vote and that sort of thing, those people would just laugh if you told them that they were like bullying the social media companies into taking things down, because the vast majority of things that they flagged for the social media companies were never taken down. Like you couldn't get better evidence that the social media companies did not feel pressured to act on this information, because they basically didn't do anything most of the time. They barely ever acted. But we felt it was really important that however the Supreme Court came down, we felt it was extremely unlikely the plaintiffs were going to prevail in this case, but we wanted to make sure that they clarified that government actors sharing truthful information with the private sector is allowed and is in fact a good thing, right? And I mentioned this as a sort of sign of where things are going to go in the next few election cycles, because even though the plaintiffs lost, and they lost pretty badly, so even though the Supreme Court said there was no standing in this case, they actually went out of their way to sort of smack down the Fifth Circuit and the trial judge. They said many of the factual findings in the case that sort of supported this whole conspiracy theory idea were clearly erroneous. The court kind of went out of its way in a different footnote 4 to say that they were clearly erroneous. I mention it because the fact that this case was brought at all was actually an attempt, ironically, to chill the speech of the people. This is a mix of government officials, academics, others who were just speaking the truth and want to spread the truth and want to give the truth primacy in terms of the information that the public is getting. And it was part of a sort of multifaceted campaign to chill those people's speech and shut down their good work. To promote democracy. So in addition to this lawsuit, many of the same plaintiffs filed lawsuits against the academic researchers in front of the same district judge in the Western District of Louisiana. Those cases have not been dismissed yet, at least as I've checked as recently as yesterday. Those cases have not been dismissed yet, even though the conspiracy theory on which they're founded is basically the same as the one in this case, and which the Supreme Court said, what the factual findings about it were clearly erroneous. There was also a congressional committee in which researchers, people from CISA, others were subpoenaed to come talk about their work in front of that congressional committee. Students were required to sit for closed-door interviews with the congressional committee. And eventually the project at least one of the universities at Stanford to do this work, to track down this election disinformation, has been defunded and basically isn't going to be in existence for the 2024 election. So all of this, I think, is a sign of what's to come, because I think we're about to see more and more, and we're already starting to see hints of it now, more and more use of both state and federal courts as a tool of spreading disinformation about elections and about the vast majority of election officials who are good people who are trying to run elections in a free and nonpartisan manner. I think we're starting to see a bunch of kind of, again, really frivolous lawsuits being filed in federal court against election officials, claiming that their voting systems violate federal law because they have not been sort of cleaning their voter rolls aggressively enough, and then trying to define a voting system as something that encompasses even a voter registration database, which it clearly does not encompass that under federal law. We're also seeing, we're starting to see litigation in state courts where we have like a state election board member in Fulton County, Georgia, is arguing that the sort of duty to certify elections in that state is discretionary, seeking a declaratory judgment that is discretionary. I think most of these cases, and I should disclose, the Brennan Center has filed amicus briefs saying that the cases should be dismissed as frivolous in quite a few of these cases. I think most of these cases aren't going to actually get relief for the plaintiffs, but they serve this like press release harassment function, essentially, to chill people from doing good things. And it relates a little bit to what Pam talked about, unfortunately, I think, in the Trump versus United States case, because just imagine all of this frivolous litigation and these Hail Mary cases being brought with the firepower of the Department of Justice and the Civil Rights Division sort of behind it. I think it would be even worse for the people that are trying to do this good work and are generally local public officials and university professors and don't have massive resources or an army of lawyers to fight back against this. So I'll stop there.
Thank you, Gary. Okay, over to Riley. And thank you all online for your patience with our video, which I believe, have just worked to restore.
Okay. How am I microphoned?
Yep.
Amazing. It is both very good and very bad luck to be at the end of such an exceptionally talented panel. I had the good fortune of having Pam for torts though, so I already knew what I was in for. I think that what is really interesting to sort of take these conversations about cases that are happening at the national level, and then also the Brennan Center does such exceptional work, also paying attention to what's going on at the state level. I think that I sort of want to draw us back for a moment to the opening quote that Pam read from John Hart Ely. I think that one of the things that is really important for us to think about in this moment where there is such extraordinary division and where I would argue that the US Supreme Court certainly has been captured by a single party and maybe has been for a very long time, that it's really on full display now. And one of the places that we can go when something like that occurs is we can go to state courts. And so there's this opportunity, and basically what I'm going to talk about are 3 state Supreme Court decisions that have happened in Montana, Idaho, and Kansas, all of which relate to voting and suffrage. But I want to sort of draw attention to this idea that, and I think it's one that we learn in law school, and we get in our heads that the courts are an anti-democratic institution. And I think that we should potentially start questioning that in some ways. I do think that, of course, when they're appointed, judges are literally not elected, and that is, at least in theory, anti-democratic. But I think that when they're doing their job, when they're not captured, right, by a single party, that what a constitutional democracy requires is for there to be at least 3 equally balanced branches that can check one another. And we can't rely on only we can't criticize the courts when they come in to protect the sort of the minority rights. This is not what the courts have been doing most recently, but when they come in to protect the constitutional rights of folks that have been targeted. And I draw attention to this largely because in Montana, we have a really different sort of set of things going on, although we may well be headed in the same direction that we're seeing sort of nationally. So my law firm, Upper 7, does a lot of state watchdog cases. And our goal is to bring cases against the state government to oftentimes in state courts and sometimes in federal court, and to essentially ensure that the Montana Constitution is upheld and the federal Constitution is upheld sort of equally across all people. And the reason why we're doing this is because, one, there aren't a lot of other people who are doing super similar things, although Law Forward is, and I saw Jeff out here. And so many people in this room, I'm sure, are familiar with Law Forward and the good work that they're doing. But I do think it's really valuable to point out that, so the Montana Constitution was written in 1972, and it contains a lot of really special and particular provisions, including, for example, a right to be free from political discrimination on the basis of political identity, contained in our Equal Protection Amendment. And I mention this in part in relation to Rucho because we are currently litigating a case where we will be using Justice Kagan's dissent to, I hope, to create a system in Montana that actually applies that discrimination against political idea in the context of a political gerrymandering case. So we have sort of an exciting opportunity to use provisions within our Constitution. We also have a right to dignity. We have a right to know that is much stronger than the Federal Information, Information Act. And we, as a result, have this opportunity to really check the overreaches of power. That's the good news. On the other hand, we also have a single party rule, and we are one of, I believe, I just looked this up, and it's like, I think it's 24 states now that have supermajorities in their political branches. And we are one of them. And the supermajority in our state is controlled by the Republicans. We have 5 constitutionally created statewide elected officials, all of whom are now Republicans. This has not been true in Montana for 100 years. So when we think about what it means for the political branches to have this concentrated power and to have this opportunity to consolidate power, to overread the mandate of the voters, what we also see is, in turn, a court that is being asked to do too much, and that will soon face, and in Montana, judges are elected. This is true in some places and not in others, but what we will see is the natural repercussion of concentrated political power across the 2 legislative and executive branches will ultimately mean a great deal of pressure on the courts. Because as of right now, we have invalidated somewhere near 5 laws at this point. We also had the actions of the governor, who recently tried to prevent the legislature from overriding a veto of a wildly popular bill. We were able to get the court to invalidate and require him to send the vote back to the legislature, who then doubled down and said that, in fact, the court giving that authority back to the legislature was an intrusion on their authority. Largely because any excuse to criticize the court at this moment in Montana is one that is embraced by the Republican supermajority. So in 2021, that's when we first elected a Republican supermajority in Montana. And they passed a series of laws that infringed on the right to vote. And this is the case. It was ultimately 3 different cases that were consolidated and went up to the Montana Supreme Court. And we had our sort of final decision in the winter, although it was a bit of a, it was a great relief. But I will tell you that we were hopeful and expecting to see most of the lower court's decision to enjoin all 4 of these laws. We were hoping to see that affirmed, and it was. But I'll just tell you briefly what those laws involved. One was an elimination of the reliance on student ID as a form of identification to register to vote and also to identify yourself at the polls. A second one was the elimination, and this one was a really big deal, of election day registration in Montana, which has existed since 2004. And it was struck down, but would have had a massive impact on voter turnout in Montana. There was another and this one's a little bit complicated, but essentially in Montana, about 70% or more of voters use the no excuse absentee voting system. And you can, as a 17-year-old who will turn 18 before an election, you can register to vote, and you can receive your absentee ballot in the mail beforehand. But different counties were administering that differently, and the legislature decided that they were going to say that actually you had to wait until you were 18 to look at that ballot. So you couldn't get the absentee ballot at the same time as all the other similarly situated adults who would also be 18 before election day, just not so close to it. And then finally, we didn't challenge this law, but an important additional law that was part of our case that was challenged by Western Native Voice and several of the tribes in Montana was a ballot interference protection act that essentially required it didn't allow organizers to be paid for helping collect absentee ballots and returning them to and this is your election organizer who shows up, knocks on your door and says, do you have a completed ballot? I would love to deliver it for you. I have, my official information. I'm affiliated with a known organization. And basically the law said you can't pay people for that work. And this is a huge problem in Montana, where the reservations, we have 7 reservations, 8 tribes, and it has a massive impact on people's ability to vote in areas where there is significantly less mail service, et cetera. All of these laws were invalidated. There was a dissent that was pretty vociferous, a little unusual for the Montana Supreme Court, to be honest. Our court is 7 justices who are sort of all over the map and a little bit unpredictable in maybe the most delightful way. And that was affirmed, that sort of the district court's injunction was affirmed across the board, and all of those laws were invalidated. Meanwhile, in Kansas, a similar case went up to the Kansas Supreme Court, and it looks really different in terms of how the Kansas Supreme Court decided to consider that. And in both cases, we have the Montana Constitution, we have the Kansas Constitution, both of which contain a right of suffrage in them. And in Montana, the Montana Supreme Court, and I don't want to get too far into the weeds here, but they decided to apply strict scrutiny to some of the claims, and they applied rational basis to some of the claims. And they said that the laws failed across the board under either analysis, but that when the Kansas Supreme Court looked at a similar case, and in this case, I'm going to remind myself because I'm a Montana practitioner, so I want to make sure that I tell you the correct things that were challenged. So there was initially criminalizing passing yourself off as an election official. This was ultimately invalidated largely because it's difficult to tell whether someone meant to pass themselves off as an election official, and the Kansas Supreme Court was concerned about that. There was a set of sort of signature verification protocols that the League of Women Voters of Kansas challenged, and we're going to come back to that one because I think it really lays out the important analysis that was happening there. And then there was also a limit on the number of ballots that an individual can collect, and the limit was 10. And the Kansas Supreme Court said that's just fine. That's within the legislature's ability to put that type of limitation on ballot collection. And I just want to note that, I know less about sort of Kansas's geography, but I can tell you that in Montana, that would have been a huge problem, right? And I think all of us can sort of see the problems with these types of limitations, and we can see that they are this intentional effort to stymie. It's to keep the ins in, right? Because we don't want the people who are going to vote differently than we expect to be allowed to do so. So we are trying to control and narrowly and make it more difficult so that you have to work very hard to vote, right? So coming back for a moment then to the signature verification process, essentially what the Kansas Supreme Court did here is they distinguished between the notion of a political right and the notion of a fundamental right. And in Montana, we have Article 2, we have a lot of fundamental rights that are set out. And our understanding of those fundamental rights is that they are almost exclusively subject to strict scrutiny, right? And in Kansas, the Supreme Court did some contortions and said, well, we actually think that the right of suffrage is a political right. And we also think that it should be balanced against another provision in the Constitution that obligates the legislature to essentially create the framework for voting and for elections, and they have to protect the integrity. By the way, we have a very similar provision in the Montana Constitution that the court said, of course, the legislature has to be able to create this framework, but they can't do it at the expense of people being able to vote. So you see 2 really different outcomes from 2 state courts, and you see the Kansas Supreme Court with dissents that are thoughtful and really hold the majority's feet to the fire in terms of saying, how can it be the case that we aren't first and foremost protecting the majoritarian, the expressed wishes of voters. And I'm going to leave Idaho aside because I do think that we're low on time. And I'm just going to sort of point out here that I think there's both hope and there's a lot of work, right? And I know that's not, I'm the right now like the day-to-day litigator on this panel. Like I was in court last week. I lost a preliminary injunction motion yesterday that I'm feeling very sad about. And I will say that we all, and the pieces of work that we are doing are, they're pressing and they're urgent, and we need to figure out how to ensure that our political system accurately reflects the wishes of the people that it is intended to represent. And one of the things that I think about often with the Montana Constitution is I think about the fourth branch. Sometimes people like to think of it as the media. I don't think that that works anymore, and largely for reasons that are related to the Murthy decision, but also just the change in sort of what we see as available information in the context of a social media era, where people are not reading and seeing the same things online one to another. So in Montana, it's the fourth branch is the people, right? And we have the ability, and I think this is also true in many other states where popular sovereignty is fully embraced by those constitutions. And I think that you have to dig deeply into what those constitutions do, what they say, what is the case law in a given state, and how do you protect the rights of the people who live there, and how do you invite them into that process? Because at the end of the day, if we don't have systems that allow us to sort of respond, if we don't have systems that sort of allow people to give that feedback back into the system, and that's where voting becomes incredibly important, and figuring out how do we preserve the right to vote by all means necessary and ensure that that's lifted up, that is sort of where the rubber meets the road. And so we're fortunate to have a good constitution, but as with the national scene and as with many specific states, that is in danger if we aren't able to make real inroads in terms of accountability and making sure that people sort of understand what's happening, and everyone should listen to this idea that we need to be active participants in bringing ourselves back on course and having balanced powers across all three branches at every level.
Thank you, Riley. Okay, thank you so much to each of our panelists. I want to remind you that there are folks coming around to collect your questions, so please keep writing those. And if you are online, please use the Q&A function. While I'm waiting for those to come up, I will ask a first question that sort of builds on something Gowrie was talking about, which is, what should we expect in the coming year? What do you all see, and maybe everyone can take a turn at this, what do you all see as the most significant threats or the most likely areas of litigation in the run-up to the 2024 election? And what should we all be watching for?
So I'll start. I think the biggest threat to the elections this fall is the loss of experienced election workers. Something like 2/3 of the folks who were election officials in 2016 or 2020 aren't there anymore. We get the elections we pay for in the United States. We have machines that are at the end of their useful life. We have new election workers. We may have trouble getting enough poll workers to staff the polls in a number of places. And I think that's the first threat. And I'll leave the kind of litigation threats for other people, and I can come back to it if other people don't mention it. But I think the sheer administration of the election is gonna be a real problem.
Yeah, on the litigation front, I know there are litigators next to me, so I have to be careful. But but to a point, something that Gowrie raised too. I mean, I think litigating for the press release rather than the victory, or for the merits, that's a really hard thing right now. There's a lot of money out there for election litigation. There's a lot of lawsuits that are being filed. You can see them all the time. You'll see a lot of news about lawsuits being filed, and there are suggestions that somehow that's going to lead to something. Many of them are dismissed. Many of them go nowhere, right? Many of them are thrown out as frivolous. So it's not great to see such a stream of litigation, but of course we know that litigators try to be aggressive. They want to sort of advocate zealously on behalf of their clients. Sometimes the seriousness of the case is in the eye of the beholder. But I think it is a really perilous place to see just volumes of litigation and trying to separate, the serious from the unserious, the things that are the press releases from the things that are really material. Again, it was pretty easy to identify after the 2020 election, a lot of that kind of litigation. But we'll see what happens in the months ahead.
Guess we'll go in order. So I'll go next. I'll actually try to bring those two ideas together a little bit. I think one thing, so I do a lot of election security advocacy, which really means like advocating for contingency plans for when people make mistakes and things go wrong, because those same contingency plans are obviously also a security measure against, some kind of foreign interference or disruption or cyber attack. And one thing that is really clear is that when people are new to a job and are under a lot of stress and pressure, they're more likely to mess up, right? So I think the sort of turnover we've seen in local election officials and in poll workers and that kind of thing does really raise the risk of mistakes happening. And then this sort of lawsuit for press release sort of makes it very difficult, I think, for judges, and is going to make it very difficult for judges to deal with the flood, because some of those instances of litigation, I'm sure, will be legitimate attempts to get remedies for mistakes that people are making, right? And it's pretty normal, I think, for judges, both federal judges and state judges, to see, a lawsuit on election day that says, there was this problem at the polls, so we're seeking a remedy of keeping the polls open later to give people a chance who maybe had to go pick up their kids from school or go to their shift at work to come back later in the evening and vote. But I am really worried about more complicated allegations and more complicated remedies, because I do think there's not a lot of huge amount of knowledge either amongst the public or among judges about the nitty gritty of election administration and contingency plans and what's out there. So for instance, I don't know how many judges are aware that the vast majority of polling places have access to emergency paper ballots that they can get and use instead if machines aren't working, right? Some places actually have to use them by law. Other places just have provisional ballots on hand for provisional voting that they could repurpose for other people to use to vote. And I also am really concerned about sort of court administration and self-governance in the context of all of this. So in 2023, in the fall, in Northampton County, Pennsylvania, there was a problem with the voting machines in the judicial retention races, in 3 judicial retention races. And it was a problem that impacted actually a very small number of voters, because it only happened when a voter voted yes to retain one judge and no to retain another judge. And any judges who are watching or in the room will know the vast majority of people vote yes on everyone in judicial retention races. So it didn't actually impact that many voters. But when voters chose that pattern of voting, they would make their choices on the touchscreen, and the printed ballot would not be what they chose. It would flip other votes, right? And apparently the machines were actually recording these votes correctly, but obviously that's really denying the voter their right to verify that their vote is being counted accurately for the record. 3 different judges issued 3 different orders in the middle of election day in that case. They conflicted with each other. One of the orders actually instructed poll workers to read a sentence out loud under penalty of being held in contempt, and that sentence had factual errors in it. They were forced to read out loud. So I really worry about, but some of that could have been solved maybe with some, advanced work to ensure, all the cases go before the same judge on election day, all these TROs, right? Consolidation, make sure that the person who's assigned to hear these emergency cases is not actually on the ballot because there are judicial races in the ballot, since that could cause delays with recusal. So I am worried about just the confluence of, people in election administration making human innocent mistakes, all this disinformation being spread about elections, and a sort of uptick in litigation, just putting a lot of pressure on a lot of different people at a time when they can't afford it.
Thank you. And we've had a request from our online audience for everyone to speak loudly.
I just completely agree. with the concerns that have been expressed. And I think that my most significant concern is around the political pressure on courts. And I think I basically already sort of talked about that. So that we can go to more questions.
Yeah. Okay.
Yeah.
Okay, thank you. So I will ask one of the, I'll try to bring together some audience questions. And this is a question about interplay between the state courts and Supreme Court of the United States. And the questions are, we're talking about state courts as being very important, but is it the case after Moore versus Harper that state courts could become less important because the Supreme Court of the United States could decide in a given case that that something is within the bounds of whatever more left available of the independent state legislature theory, or otherwise violate some sort of due process interest. And so, could the Supreme Court, based on your all's understanding of Moore versus Harper, actually step in and stymie something that a state court might otherwise do that would be sort of pro-democracy?
Do you want to start with somebody else the second this time around? And
Go ahead, Derek.
Well, I don't know. So after Moore versus Harper, where the Supreme Court says as long as the judiciary is not arrogating the power that was given to the legislature and exercising sort of traditional judicial review, we're going to be okay. We're not going to review it. And there has always been, I think, in the election law community, a sense that, if judges go too far, that they could be a due process violation. We've seen that happen before. So there was always something out there as a check on judicial power existing under the Constitution, thinking about due process for all elections, state and federal. And then now there's this additional, maybe a little sliver of cases involving federal elections where maybe the state court could go too far, and maybe it's in some universe that's beyond the due process questions. So my sense is that it's going to be litigated a lot. My sense is, though, that I'm not sure how much success we're going to see out of it. I think a lot of the litigation we saw in 2020 were changes made during COVID in circumstances that, are not going to be replicated in 2024. So my sense is that the risk is very low, but I tend to say the risk is low about a lot of things. And so maybe others have different risk tolerances.
I could just add, I do think we are still seeing some remnants of litigation challenging really administrators' discretion to interpret election law in a way that is pro-voter, right? So we just saw in Wisconsin a Supreme Court case overturning a prior Supreme Court case that had alleged that using drop boxes was sort of going beyond the types of voting methods that the legislature had provided for. Wisconsin Supreme Court recently affirmed the right of election administrators to do that. They'd actually been doing it since before the pandemic, right? There's still some of this kind of straggler litigation, I would say. So in Arizona, there was a lawsuit filed to challenge the use of drop boxes similarly, and on a kind of similar, you're going beyond what's explicitly specified in state election law. That failed. The trial court just ruled against the plaintiffs in that case. They also had another argument that administrators were going beyond the election laws by when they got absentee ballots back, matching the signature on the envelope to more than just one signature in the voter's registration record, allowing a few different signatures that were in the file to be the basis of comparison. They said that was going too far. That also failed. Those plaintiffs have filed a notice of appeal in those cases. They're in state court. So there is some of the straggler litigation. There's this whole absentee ballot litigation happening in Pennsylvania, which the Department of State may have just obviated by saying, let's solve this problem of sometimes voters return ballots on time but fail to put the correct date on the envelope. Let's solve it by making all the counties actually just print the whole calendar year on the envelope instead of saying 20 blank blank. They need to say 2024. So fewer voters make that mistake. So I think we do have some of that. And I do see a lot of that as trying to ultimately get in there under what's left of that ISLT theory after Moore v. Harper. But I don't see a lot of these cases being super successful, actually. Yeah.
do have reason to think that the Secretary of State in Montana will be appealing the decision made by the Montana Supreme Court on all 4 laws because they have louder. Because they have actually, is that better? Okay. So the Secretary of State of Montana has asked for an extension to file a petition for cert to the U.S. Supreme Court on the Montana Supreme Court's decision as to the 4 laws, none of which were challenged on federal grounds, and on using entirely the independent state legislature's doctrine as the theory. I will confess, I don't think that they are likely to have a lot of success, and it doesn't seem like a great way to use their resources, but we look forward to writing a brief in opposition if requested to do so.
Yeah, I'll just add that the thing that worries me is the relationship between state administrative agencies, state courts, and the U.S. Supreme Court. One question is to what extent states are going to be affected by the kind of flavor of administrative law in federal court, which is, as those of you who follow administrative law know, the Supreme Court this year got rid of what's referred to as Chevron deference, which is when there's a law that is ambiguous or can be read several different ways. If there's an agency that's charged with enforcing that law and the agency gives a reasonable interpretation of the law, the courts should defer to that rather than saying, well, yeah, that's reasonable, but we think here's a better one. And that's now gone in federal court. And I wonder to what extent that's going to play out both in state courts themselves and in how the Supreme Court treats administrative interpretations of state laws themselves, which is whether it's going to say, well, that clearly exceeds what the administrative agency should be entitled to do and is taking over what the legislature is supposed to. And now it's gone. It's very hard to know because the motivated reasoning in these cases can be so powerful. That's why you really want all of these things done before the election season begins, because at that point, it's not necessarily quite as clear who's going to be benefited and who's going to be burdened. But when you find these things happening during the election cycle, or even more after the election has occurred, the motivated reasoning in some courts is going to be, the pressure on courts is going to be extreme.
Can I just add that the best example I think of that actually is looking at these these state Supreme Court decisions and looking at how much they actually look at their own constitution versus thinking about what the Supreme Court has said, or right, and to what extent federal law actually dictates what different states' laws are. And you really see a great deal of diversity. One of the things that and Emily, wherever Emily is, that there was the brief that the State Democracy Research Initiative put together in the Montana Supreme Court, really making this point, look, you're okay to apply strict scrutiny because other states are doing it too. You aren't going to be way out on your own. But this is the problem I think that we have, is that sometimes there is too much persuasive power given to the U.S. Supreme Court when state Supreme Courts are making decisions about interpreting their own constitutions, which may or may not track very closely with the federal constitution, because often they're newer and they reflect more modern principles.
Terrific. So it is now time for me to make the CLE announcement for our virtual participants. The passcode today is summer, the best month. That is summer, SUMMER, and case does not matter. I think we have time for one more question today, and I want to ask about the redistricting cycle that we hope has now concluded because it is 2024. And I think it's just a general question. What should this audience take away from the most recent round of redistricting? Sort of highlights, lowlights, themes, takeaways. How can you educate us about the latest redistricting cycle?
if people are interested in hearing about the political gerrymandering in Montana, I can talk about that for a moment. And I think there's some interesting points of comparison, but then I'm hoping the professors will jump in. Um, so in Montana, we have a redistricting commission that was built into a bipartisan redistricting commission that was built into the Montana Constitution, which is to say that the Montana Constitution itself requires that all redistricting occur through this commission. And there are, I'm going to forget the exact makeup, but it's a really carefully thought out makeup where appointments are given to specific entities to ensure balance, right? And it's been fairly effective in ensuring, at the very least, that there is appropriate distribution of representation, politically, rural, urban, all of the above. The Public Service Commission in Montana, which runs energy policy, right, for the state. I don't, if energy policy is maybe not quite right, but they're sort of a commission that oversees electric, garbage disposal, all of these different things that you can sort of imagine. It has 5 members, and it was created after the Montana Constitution was written in 1972. And so the legislature decided to distribute to itself the power to redistrict the PSC commission districts, which there are 5 of them across the state. And in 2021, we invalidated them for violating one person, one vote, because they were completely, the rural areas had significantly more power than urban areas in Montana. The result was a court drawn map, and by a federal 3-judge panel. And the legislature was very upset that we had succeeded in doing this, despite the fact that it essentially had no impact on the makeup of the commission. And they passed a law that split up. And if anybody and I'll just sort of say, there's some basic districting criteria. One is that you don't split up communities of interest. Another is contiguity. You kind of keep things compact and contiguous. So you're not drawing like the shape of, your favorite stuffed animal or something onto a map and saying, well, this works, because we're trying to capture, different voting populations and put them together to decrease power or increase power. They split 5 of the major urban areas in Montana. Just so you know, there aren't a lot of major urban areas in Montana. I think there might be 7. So, right, almost all of them. You see in this map just completely cutting through the Native American reservations, cutting through communities of interest in other ways, also cutting through counties. None of this has been done before. They used the districts that the legislature had redistricted for the representatives and the senators. So when you take, you have these very fancy redistricting professionals who have extraordinary capacity to run analysis to see how likely is it that this is politically gerrymandered. And the Rucho case followed sort of very similar lines. And we hired this expert, and she ran 100,000 or more maps and compared them. And the PSC districts in Montana are so gerrymandered to ensure the outcome of a Republican that there is essentially no statistical way in which that couldn't have been the only motivating factor, essentially. No matter how else you sort of put all these other important factors in. So we're litigating that on the political identity, the protection against discrimination on the basis of political identity under the Montana Constitution. And we're following very closely what's happening sort of on the national landscape, because the way that Rucho was written, and I don't know whether Anderson will make a difference for us ultimately. I don't think that it will, because of the strength of the Montana Constitution on that front. But we're sort of in this interesting place where it really illustrates the power, on the one hand, of having a districting commission, and then when you leave it in political hands, when you give the legislature the power to decide who's in, who's out, at the risk of really beating a dead horse, I just really like that point. I think it's really powerful. When you give the people in power the opportunity to decide whether or not they're going to get to stay in power, they will do everything they can to ensure that they will. And so I don't know if it sort of gets into, I think, a good set of examples. I don't think it answers the question necessarily of where we're going, unless basically you sort of lean into this idea that where we are going is whether or not we have created structural systems that protect us against majoritarian politics that lean into overreach and that allow sort of a few people to gain too much power. And I think, do the professors have any good additions?
We're just about over, but if Pam or Derek have like 30 seconds on the redistricting cycle that was, we would welcome that before we wrap up.
Well, it's the redistricting cycle that is, because there's still litigation going on in a number of states, including South Carolina, Louisiana, obviously Montana. One of the things we've learned, the two things we've learned, one is that redistricting commissions, if they're set up properly and the like, dampen down at least the most extreme versions of partisan gerrymandering. Although sometimes those commissions get captured in weird ways. The second thing we've learned is that the incentive to do this litigation is so tremendous that if one piece of litigation gets pinched off, for example, Rucho has pinched off litigation under the federal constitution for gerrymandering, it will move to state courts, or it will turn into one person, one vote litigation, or they will use the Voting Rights Act to go after it or the like, because the stakes are really high.
Yeah, I'll just say, I think the Supreme Court over the last decade or so on kind of a bipartisan basis in some sense has said, just like, stop bringing these claims. And I think this is, part of why they keep coming, Texas needs to exclude non-citizens when it's redistricting. Court says, don't come to us with that. We need to rethink how we do the Voting Rights Act in Alabama. Don't come to us with that. We need to litigate these partisan gerrymandering claims. Don't come to us with that. So there's been a lot of sort of punting these things off over the last decade that has, again, or one of them is redistricting commissions for Congress are unconstitutional. Don't come to us with that. You can run your commission. So there are a lot of things in which sort of the process is playing out politically or in the states because the federal courts keep sort of stepping back.
Okay, we are out of time. So I want to say one more time that the passcode is SUMMER, SUMMER. I want to thank our partner, the Elections Research Center, and our sponsor, Stafford Rosenbaum, and most of all, our excellent panelists. Thank you so much.